Welcome to the Employment, Law, and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 248 of the Employment, Law, and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where together with my colleagues, we provide advice and assistance to both employers and employees on all aspects of employment law throughout the UK. So we cover the law in England and Wales. If you require any support or assistance with employment law, maybe you're bringing an employment tribunal claim, or you are defending an employment tribunal claim, or you're just becoming overwhelmed with the pace of change in relation to HR and employment law, and you need some support. Well, we offer a variety of services, including monthly retainer services and our flagship HR Harbour service, where for a fixed monthly fee, you can receive unlimited support and assistance in relation to HR and employment law. So if you'd like any more information about the services that we provide, or would like to find out how we can help you, please don't hesitate to get in touch. You can contact me by email. It's alison@realemploymentlawsadvice.co.uk. In this week's episode of the podcast, I'm going to be giving you an update and reminder about annual leave and holiday pay. So without further ado, I'm going to get into this week's featured content. Okay, so I wanted to cover in this episode of the podcast a bit of an update and review in relation to holiday and holiday pay. And the reason being is because there's been various changes over the last few years that has been somewhat confusing for us as practitioners, but certainly I know for managers, employers and HR professionals. And it is an area that often people have questions about, and it's not entirely clear and clear cut. So hopefully in this episode, I will be able to make things a bit clearer for you and answer some questions that you may have, or just to reaffirm that you're doing things correctly in relation to holiday. Now, starting with the very basics, who has the right to holiday and holiday pay? Now, there are two types of persons who have the right to holiday and holiday pay. The first is employees. So employees in the traditional sense, as you would imagine, would be entitled to holiday and holiday pay. But also workers have the right to holiday and holiday pay. So it's those people who don't quite meet the definition of an employee, but do have rights for the purposes of the working time regulations. So a worker is defined as an individual who has entered into or works under A, a contract of employment, or B, any other contract, whether express or implied, and if it is express, whether oral or in writing, whereby the individual undertakes to do or perform personally any work or services for another party to the contract, whose status is not, by virtue of the contract, that of a client or customer of any professional or business undertaking carried out by the individual. So this meets those people who don't quite, as I say, meet the definition of employee, but aren't necessarily self-employed persons and therefore in business for themselves. And there have been a whole host of cases in relation to worker status and defining worker status, including all of those about the gig economy. So you might recall the Uber cases, the Deliveroo cases, the Pimlico plumber case. So where the courts and tribunals have had to determine the status of an individual who isn't necessarily an employee. And so those people who are defined as workers are entitled to holiday and holiday pay. Now, worker status and determining someone as a worker or not is a topic for an entirely different podcast. And I'll put a link in the show notes to some resources in relation to that if you still have questions. And maybe that's something we'll cover off in the future, again, by way of a reminder for some of the case law on that. But just so you know, both workers and employees have the right to holiday and holiday pay. Now, in relation to holiday rules, so that is the rules around when holiday can be taken, when a holiday year starts and ends, all of those sorts of things, notice about holiday. This is contained within the working time regulations. So the working time regulations stipulate in law all of the things that you need to know about how holiday works in practice. Now, the working time regulations is one of those employment rules which can be varied and is quite frequently varied by the terms of an employee's contract or by a relevant policy that's implemented. So most employers have a policy around holiday so that they would include things like the holiday year. So having the holiday year normally from either the 1st of January or the 1st of April, depending on how your business operates. So things like the holiday year and when people are allowed to take holiday and the amount of notice people are meant to give to take holiday, that's all set out in your holiday policy or your contract, so you can vary that. But in the absence of anything that's set out in writing and agreed in relation to holiday rules, you would default to the working time regulations. Now, when it comes to calculating holiday entitlement, it's important that we understand, and just to reiterate, that the calculation of holiday entitlement, so that is the amount of time a person is allowed to take off each holiday year, is different to the calculation of the pay that they receive during that time. And quite often, in my experience, people get confused about the two, and I think the simplest way of doing it, so as not to confuse yourself, especially when you have unusual circumstances like part-time workers, part-year workers, etc., is to have a set calculation, how you're going to work out what their holiday entitlement is, and then how you're going to work out what they receive by way of pay when they take holiday. Okay, so by law, all employees and workers are entitled to 5.6 weeks leave. Okay, and so if somebody works 5 days a week, 5.6 weeks leave is 28 days. Quite simple. If somebody works 4 days a week, the way in which you calculate their holiday entitlement is to times 4 by 5.6, which gives you 22.4 days, so rounded up 22.5 days per year. And then the same for someone who works 3 days a week, etc. Now, if you calculate holiday entitlement in hours, then you would do this by calculating the number of hours per week, and you times that by 5.6 to give you the annual holiday entitlement in hours. Okay, so that's where people have a guaranteed hours contract and they work a set number of days or hours each week. Then you would calculate their holiday based on the 5.6 weeks leave. And if you offer enhanced holiday entitlement, so you give people more than 5.6 weeks, then you would just calculate the pro rata amount for part-time people by timesing it by the same amount as you would for a full-time person. So let's just say you are a generous employer and you give your employees who work full-time 6.5 weeks leave per year. Then the way in which you calculate it for somebody who works part-time to ensure that they receive the same amount pro rata as their full-time colleagues would be to times 6.5 by the number of days they work each week. And the same thing would go in relation to hours. Now, when it comes to a decision as to whether you calculate annual leave in hours or days, that is entirely up to you, and you can do it universally across the organisation. So you can calculate everybody's in days or everybody's in hours. But however you do it, you need to be consistent. And quite often what happens is if somebody works fluctuating hours throughout the week, so they don't have the same pattern each day, then employers will tend to calculate their holiday entitlement in hours. So for example, you have somebody who works Monday 9 to 5, Tuesday 9 to 5, and Friday 9 till 12. In that scenario, you can of course use days, but if somebody always took a Friday as their holiday day, then they would have less hours of holiday than if they took every Monday, for example. So in that scenario, it would be advisable to calculate their holiday in hours. Now, of course, if somebody starts or leaves partway through a holiday year, then you would need to calculate pro rata what their entitlement is for the number of months or weeks that they will be working. And the best thing to do in relation to this is to then round it up to the nearest half or whole day, because quite often you'll end up with a odd calculation where you're trying to work out, a number of hours. And if you don't calculate the overall entitlement in hours, then it can be quite confusing. Now, the calculation of a holiday entitlement for people who have guaranteed hours is fairly easy, or guaranteed days of work. Again, fairly easy to do based on the statutory 5.6 weeks, or if you do enhanced, as we said. But when it comes to somebody who doesn't have fixed hours, then fortunately, the law changed last year and created 2 new definitions whereby you can do something slightly different in relation to the calculation, and where you can do something slightly different in relation to the calculation of holiday entitlement. So the first is irregular hours workers. So that is somebody whose hours vary each week. So that would include somebody who is on a 0-hour contract, for example. So if their contract is wholly or mostly variable, then they would be classed as an irregular hours worker. The second type of worker that this applies to is part-year workers. So in relation to a leave year, if under the terms of their contract they're required to work only part of that year, and there are periods within that year of at least a week when they're not required to work, such as people like teaching assistants who are only employed for term time periods, for example, then they would be classed as a part-year worker. Now, since the 1st of April last year, if you have somebody who is an irregular hours worker or a part-year worker, then you are entitled to be able to calculate their holiday entitlement on the basis of the hours that they've worked and have accrued. So what this means is that for each hour that they work, they accrue 12.07% of the actual hours worked in that pay period. And the 12.07% is on the basis that they have the statutory minimum entitlement of 5.6 weeks. So in reality, what you would do is, if you pay monthly, is at the end of the month, you would calculate how many hours they've worked that month and then times that by 12.07% to give you their accrued annual leave entitlement for that month. And with irregular hours workers or part-year workers, you can stipulate that they can't take their holiday until it has actually accrued, and that includes after they've been employed for more than a year. So you may know that if somebody has been employed for less than a year, so in the first year of employment, you can stipulate that they can't take holiday until it's accrued. Once they've been employed for a year, then you can't prevent them from taking their holiday all at once or before it's accrued. But if they are an irregular hours worker or a part-year worker, then you can still use the accrual method even after they've been with you for more than a year. Okay, so to summarise, in relation to the calculation of holiday entitlement, so in relation to somebody who has guaranteed hours that are set out in their contract terms, then you would use the 5.6 weeks to calculate their holiday entitlement for the full year. If you have someone who is employed as an irregular hours worker or a 0-hour contract or a part-year worker, then you can use the 12.07% to work out their accrued entitlement based on the hours that they have worked. And that gives you the holiday entitlement for each type of worker. So moving on in relation to holiday pay. Now, holiday pay used to be fairly simple, as in you would just pay somebody their basic pay when they took holiday. Now, if somebody just receives basic pay, they don't have any enhancements, any overtime, any commission, or any regular bonuses, then you would still do that. So somebody who's on a set salary that they're paid each month, and that doesn't change month to month, then you would just pay the same when they take holiday. It's fairly straightforward. But following a number of cases that have gone through the courts and tribunal systems, it has been set out in law that in order to comply with the working time regulations, you need to incorporate within holiday pay any payments that are made regularly to that employee over and above their basic pay. So that is to say, when somebody takes holiday, they should be paid essentially the same as if they were working. And what this means is that for those people whose pay changes each month or each week, depending on their pay period, that you have to use the calculation of the average of the last 52 weeks' pay in order to decide how much you're going to pay them when they actually take their holiday. So let's take the example of somebody who works 40 hours a week and is paid a salary of £1,500 a month. If in addition to that £1,500, they're paid an extra £500 a month for commission, and they do a bit of overtime, so they get another £200 or approximately £200 each month for overtime, then when they take their holiday, all of those additional payments would be taken into consideration, and therefore when they take it, they wouldn't actually just receive their normal basic pay of £1,500. They would include a calculation of the average that would represent what they would normally be paid, to include their commission and overtime, etc. Now, in relation to those people who are irregular hours workers or part-year workers, you have two options now. The first is to pay them when they take their leave, and if you do that, then again you would need to calculate their pay based on the average of the 52 weeks pay that they've worked, so in the same way as you would for a regular hours worker. Or you have the option now to legally and legitimately pay someone rolled up holiday pay. Now, I know that for 0-hour contract employees, and particularly in this sort of seasonal workers, rolled up holiday pay was used fairly frequently before anyway, even though it was unlawful to do so, because it was much easier to administer and actually much better for the workers. But now, since the law changed, you can actually pay rolled up holiday pay for those irregular hours or part-year workers. And so what you do is, instead of paying the employee when they actually take their leave, you pay them a percentage of their holiday pay in each pay period. So again, you calculate using the 12.07% of their earnings based on the hours worked, and you pay that in each pay period. And as long as you clearly mark this out as a separate item on their pay slip, then this is perfectly lawful to do. But what it does mean is that when employees actually take holiday, they won't receive a payment for that time. So they will receive a proportion of their holiday pay each month, but not actually receive anything when they go away. Now, of course, if you already have irregular hours workers or part-year workers and their contract stipulates that they're paid when they take leave, if you wanted to change to the rolled up holiday pay option, then it would be a variation of their contract, and you would need to get their permission to do so, or their consent or agreement to make the change, or you'd have to go through a consultation to do so. But certainly if you're taking on new employees on an irregular hours or part-year contract and you want to use rolled up holiday pay, then you can start utilising that now. Fortunately, when the change came about to the law last year, full guidance and some worked examples have been set out on the .gov website, and I'll put the link in the show notes for you to have a look. And you can also find on the .gov website a handy holiday calculator, which will help you to calculate holiday for regular hours and irregular hours workers. So to summarise in relation to holiday pay, for those employees whose pay doesn't change and isn't varied, you just pay them the normal amount when they take leave. But for anyone whose pay is varied throughout the year, when they take their leave, you would need to calculate that based on the 52 weeks average pay. And for irregular hours or part-year workers, if instead of doing the average pay, you can use the rolled up holiday pay system to pay them a percentage of their holiday entitlement and holiday pay each pay period. Now, I know in relation to the calculation of holiday pay, there are still a number of organisations who haven't moved over to using the 52-week average and are instead still continuing to pay employees basic pay when they take their holiday, even though they regularly receive additional payments, either for overtime, for commission, or for bonuses, etc. If you are one of these organisations, it's really important that you take steps now to seek to comply with the law as it currently stands. And if you're not sure on what to do, to seek some advice on this to make sure that you are calculating your holiday pay correctly. The reason for this, and the reason for this advice, is obviously you want to avoid an employment tribunal claim, having to pay back pay of holiday to employees, but also once the Employment Rights Bill comes in, there will be an obligation to keep records to demonstrate your compliance with holiday entitlements. So you would be required to keep records about holiday pay and leave, and you'll have to keep this for 6 years, and a failure to comply could be a criminal offence. So not only will you have to now keep detailed records about holiday pay and leave, if you don't do so, it could be a criminal offence. And in addition to that, we also have the proposal under the Employment Rights Bill to bring in the Fair Work Agency, who will be policing the holiday rules, so making sure that employers are complying with the holiday obligations in relation to pay and leave. So you need to get all of your ducks in a row now, in my view, to make sure that you're complying. And it might mean that you have to pay some employees some additional pay that they have missed out on in order to avoid a dispute. But there are ways of dealing with this and handling it. So do get in touch if you'd like any help in relation to that. And as I say, please stop burying your head in the sand in relation to this. Do take some action to change the way that you're paying for holiday if you're not already doing what you should. So to recap in relation to what we've covered in this episode of the podcast, it's just been a bit of an update and overview in relation to holiday. So the first thing to note is that how you calculate holiday entitlement is different to how you calculate holiday pay, and you should ensure that you have two separate ways in which you are working this out and recording it. If you are unsure about what you need to do, or you have any questions, or if you think that perhaps you might not be doing it right, then why not get in touch? It'd be great to have a chat with you about it and answer your questions. And if you do have any questions that you want to add, please put them in the show notes or do not hesitate to get in touch. You can email me. It's alison@realemploymentadvice.co.uk. I hope that you have a fantastic 2 weeks ahead, and I look forward to bringing you the next episode of the podcast in a fortnight's time. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.